The Trump administration has just announced sweeping changes to green card regulations that are already taking effect across the United States. Immigration officers at ports of entry, USCIS offices nationwide, and consular posts around the world have received new directives that fundamentally alter how green card applications are processed, approved, and maintained. If you currently hold a green card, are applying for one, or plan to sponsor a family member, the rules you knew last month may no longer apply. The information I am sharing today could determine whether your application succeeds or fails, whether your green card remains valid or gets revoked, and whether your American dream stays within reach or slips away. Every detail matters and every minute counts. Welcome back to US Visa Info, your most trusted source for accurate, timely immigration news and practical guidance for navigating the United States immigration system. My mission is to cut through government jargon and political rhetoric to deliver the facts you need to protect your immigration status and achieve your goals in America. If this is your first time here, please subscribe to US Visa Info and activate notifications because immigration policy is shifting rapidly under this administration, and staying informed is your best defense. Today we are breaking down the Trump green card rule changes that went into effect immediately, analyzing who is affected, what has actually changed, and most importantly, what you must do right now to safeguard your status and your future. The first major change involves the public charge rule, which determines whether an immigrant is likely to become dependent on government benefits. The Trump administration has reinstated and significantly expanded the public charge test that was previously blocked by courts. Under the new policy, immigration officers must consider a much broader range of factors when evaluating whether a green card applicant might use public benefits in the future. This applies to family-based green card applications, employment-based adjustment of status cases in certain circumstances, and consular processing abroad. Specifically, the updated public charge rule now weighs your receipt of any public benefit, including Medicaid, food stamps, known as SNAP, housing assistance, and cash assistance programs much more heavily than before. Previously, only cash benefits counted significantly against you. Now even non-cash benefits can be grounds for denial. Immigration officers are instructed to look at your entire financial picture, including income, assets, debts, credit history, education level, English proficiency, age, and health status. If you have received any public benefits within the past 36 months, even if you were legally entitled to use them, this creates a significant negative factor in your application. Let me give you a concrete example of how this affects real people. Maria from California applied for her green card through her U.S. citizen husband. During the pandemic, she lost her job and temporarily received unemployment benefits and Medicaid for 6 months while searching for new employment. She found a good job, has been working steadily for 2 years, and her husband earns $70,000 annually. Under the previous rules, her brief use of unemployment and Medicaid would not have been disqualifying, because these were temporary benefits during a genuine emergency. Under the new Trump policy, USCIS denied her green card application, stating that her past use of public benefits demonstrates she is likely to become a public charge in the future, despite her current stable employment and her husband's solid income. The second major change affects the affidavit of support requirement. When a U.S. citizen or green card holder sponsors a family member for a green card, they must submit Form I-864, the affidavit of support, proving they can financially support the immigrant at 125% of the federal poverty guidelines. The Trump administration has increased scrutiny on these affidavit and now requires much more extensive documentation to prove income and assets. Previously, submitting your most recent tax return and a letter from your employer was often sufficient. Now, USCIS demands 3 years of tax returns, 6 months of pay stubs, bank statements showing consistent account balances, verification of employment directly from your employer, and in many cases, additional evidence of assets if your income is borderline. Furthermore, USCIS is now rejecting affidavit of support much more frequently for technical errors or insufficient documentation. If your tax returns show fluctuating income, if you have changed jobs recently, if you are self-employed with irregular income, or if you have any tax liens or unresolved tax issues, your affidavit may be rejected even if your current income exceeds the requirement. In these cases, USCIS requires a joint sponsor, which means finding another U.S. citizen or green card holder willing to take on full financial responsibility for the immigrant. Many families are discovering that relatives who previously agreed to be joint sponsors are now unwilling to accept the liability under the stricter enforcement environment. The third significant change involves employment-based green cards and the ability to change employers after filing. Under long-standing policy, if you have an approved I-140 immigrant petition and your I-485 adjustment of status application has been pending for more than 180 days, you can change to a similar job with a new employer without jeopardizing your green card. This portability provision has been crucial for professionals waiting years in the green card backlog. The Trump administration has not eliminated this rule outright, but USCIS has issued new guidance that dramatically restricts what qualifies as a similar job. Previously, if you were sponsored as a software engineer and moved to another software engineering position with comparable or higher salary, that was clearly portable. Under the new interpretation, USCIS is demanding that the new job match the original labor certification in minute detail. If your original job required expertise in specific programming languages or particular industry experience, your new job must match exactly. Small differences in job duties, required skills, or even job title can now result in USCIS denying your adjustment application even after years of waiting. Officers are issuing requests for evidence demanding extensive documentation comparing every aspect of the original and new positions, and many of these cases are ultimately being denied. Rajesh from Texas illustrates this problem. He was sponsored for a green card as a senior software engineer specializing in cloud infrastructure. His I-40 was approved in 2020, and his I-485 has been pending since 2021. After more than 180 days, he changed employers to a better-paying position with the same title and similar responsibilities. However, his new role involves slightly different cloud platforms than those specified in his original labor certification. USCIS issued an RF questioning whether the positions were truly similar, and despite submitting detailed expert opinions and documentation, his case was denied. He now faces deportation unless he can find an employer willing to restart the entire green card process, which takes years. The fourth major policy shift concerns travel for green card holders and the presumption of abandoned residence. Immigration law has always required green card holders to maintain the United States as their primary permanent residence. If you remain outside the U.S. for more than 1 year without a re-entry permit, your green card is automatically considered abandoned. Trips of less than 6 months are generally safe, while trips between 6 months and 1 year require explanation. The Trump administration has instructed Customs and Border Protection officers to apply much stricter scrutiny to green card holders returning from any international trip, regardless of length. Officers at airports and land borders are now conducting intensive secondary inspections of green card holders who have been abroad for as little as 3 or 4 months. They are examining your entire travel pattern over the past several years, not just your most recent trip. If you have made multiple extended trips abroad, even if each individual trip was under 6 months, officers are questioning whether you truly maintain U.S. residence. They are asking detailed questions about your employment, housing, family ties, bank accounts, tax filings, and community connections in the United States. If your answers suggest you spend more time abroad than in the U.S., or if you cannot immediately produce documents proving strong U.S. ties, officers are threatening to confiscate your green card or requiring you to sign forms abandoning your status. James, a green card holder originally from the United Kingdom, experienced this firsthand. He works for a multinational company that requires him to spend significant time at their London office. He maintains an apartment in New York, files U.S. taxes, and has always returned to the U.S. before the 6-month mark on each trip. When he returned from a 4-month assignment in London last month, CBP officers at JFK Airport detained him for secondary inspection for over 3 hours. They reviewed his travel history, questioned him intensively about his job, his apartment, and his ties to the U.S. versus the U.K., and ultimately allowed him to enter, but stamped his passport with a warning that future entries might not be permitted. He was told that his pattern of extended trips suggests he does not genuinely maintain the U.S. as his permanent home, despite never violating the 6-month rule. The fifth significant change affects conditional green card holders, those who obtained their green cards through marriage to a U.S. citizen and must file Form I-751 to remove conditions after 2 years. The Trump administration has dramatically increased denials of I-751 petitions and has instructed USCIS to scrutinize these applications for any evidence of fraud. Previously, if you submitted credible evidence that you entered the marriage in good faith and it later ended in divorce, USCIS would approve your petition to remove conditions based on that evidence. Now, USCIS is denying many of these cases, particularly if the marriage ended in divorce before the 2-year anniversary. Officers are demanding overwhelming proof that the marriage was genuine, including joint financial accounts, joint leases or mortgages, insurance policies naming each other as beneficiaries, photographs spanning the entire relationship, affidavit from friends and family, travel records, and more. Even when applicants provide extensive documentation, USCIS is issuing denials based on minor inconsistencies or insufficient evidence of commingling finances. Many conditional residents are being placed in removal proceedings where they must defend their cases before an immigration judge, a process that can take years and costs tens of thousands of dollars in legal fees. Jennifer from Florida married a U.S. citizen and received a conditional green card. The marriage was genuine, but after 18 months her husband became abusive and she left for her safety. She filed for divorce and submitted her I-751 with evidence of the abuse and documentation showing the marriage was entered in good faith. USCIS denied her petition, stating that the evidence was insufficient and that the short duration of the marriage raised questions about her intent. She is now in removal proceedings, facing deportation to a country she left over a decade ago, despite being a victim of domestic violence. The sixth policy change involves the discretionary factors USCIS considers when adjudicating green card applications. Immigration officers have always had discretion to approve or deny applications based on the totality of circumstances. The Trump administration has issued new guidance expanding the factors officers should consider as negative discretionary issues. These include any history of unemployment, any gaps in health insurance coverage, any unpaid debts or poor credit history, any interaction with law enforcement even if no charges were filed, any past immigration violations even if waived or forgiven, and any evidence that you might need public benefits in the future based on your occupation or health status. This expansion of discretionary denials means that even if you technically qualify for a green card under the law, an officer can deny your case based on factors that previously would not have been grounds for denial. For example, if you have student loan debt, if you had a gap in employment while caring for a sick family member, if you were pulled over for a traffic violation that was dismissed, or if you work in an industry with lower average wages. Any of these factors can now be cited as reasons to deny your application. The seventh major change affects asylum seekers adjusting status to green card holders. Asylum seekers who have been granted asylum in the United States are eligible to apply for a green card after 1 year. The Trump administration has implemented new procedures requiring asylum-based green card applicants to prove that conditions in their home country remain dangerous and that they still have a well-founded fear of persecution. Previously, once you were granted asylum, adjusting to a green card was largely procedural. Now USCIS is conducting full reevaluations of whether you still qualify for protection. And if conditions in your country have improved or if the original basis for your asylum is questioned, your green card application can be denied and your asylum status can be terminated. The eighth change involves medical examinations for green card applicants. All green card applicants must undergo a medical examination by a USCIS-approved civil surgeon. The Trump administration has updated the list of inadmissible health conditions and has instructed civil surgeons to apply stricter standards. Conditions that previously received waivers, such as certain mental health diagnoses or histories of substance abuse, are now more likely to result in findings of inadmissibility. Additionally, vaccination requirements have been expanded, and failure to receive all required vaccinations results in an incomplete medical exam and denial of the green card application. The ninth significant policy shift concerns the naturalization pathway for green card holders. While not directly a green card rule, the Trump administration has made changes that affect long-term green card holders planning to become U.S. citizens. USCIS has increased the scrutiny of naturalization applications and is denying cases for issues that would have been overlooked previously. If you have any discrepancies between your green card application and your naturalization application, such as differences in employment history, travel dates, or addresses, USCIS may deny your citizenship and in some cases initiate proceedings to revoke your green card based on alleged fraud in the original application. Carlos from Arizona has been a green card holder for 7 years and applied for naturalization. During his citizenship interview, the officer noticed that an address listed on his original green card application did not exactly match the address on his tax return from that year. The officer accused him of providing false information on his green card application and denied his citizenship. USCIS then issued a notice to appear, initiating removal proceedings to take away his green card based on alleged fraud. Even though the address discrepancy was a simple clerical error with no material impact on his eligibility. The 10th change involves the premium processing option for certain employment-based cases. USCIS has suspended premium processing for many green card-related applications, meaning applicants cannot pay extra for faster processing. This results in dramatically longer wait times, sometimes years, leaving applicants in legal limbo. For people waiting for their I-485 to be processed, this means extended periods of uncertainty where they cannot travel freely, cannot easily change jobs, and live in constant fear that a policy change will destroy their case before it is decided. What can you do to protect yourself under these new Trump green card policies? First and foremost, if you currently hold a green card, document everything. Keep meticulous records of your time in the United States versus abroad. Maintain evidence of your U.S. ties, including tax returns, employment records, lease agreements, utility bills, bank statements, and proof of community involvement. If you must travel internationally, especially for extended periods, consult with an immigration attorney before you leave. Consider obtaining a re-entry permit if you will be abroad for more than 6 months. When you return to the U.S., have all your documentation easily accessible in case you are sent to secondary inspection. Second, if you are applying for a green card, assume that USCIS will scrutinize every detail of your application. Do not submit anything without careful review. Ensure your affidavit of support is bulletproof with extensive financial documentation. If you have ever received any public benefits, consult an immigration attorney before filing to assess whether you can overcome the public charge grounds of inadmissibility. Be prepared for lengthy delays and multiple requests for evidence. Respond to every RF promptly and thoroughly with the assistance of qualified legal counsel. Third, if you are on a path to a green card through employment, be extremely cautious about changing jobs even after the 180-day portability period. The new interpretations of job similarity are so strict that what seems like an obviously similar position may be deemed different by USCIS. Before accepting a new job, have an immigration attorney review the job description and compare it in detail to your labor certification. Consider whether the risk of denial is worth the job change, or whether staying with your current employer until your green card is approved is the safer choice. Fourth, if you are a conditional green card holder, start preparing your I-751 petition well before the 2-year anniversary. Gather every possible piece of evidence proving your marriage was genuine. If your marriage has ended, document the reasons and consult an attorney about whether you qualify for a waiver. Do not assume that a straightforward case will be approved quickly or without challenge. Fifth, if you are an asylum-based green card holder or applicant, be prepared to reprove your asylum claim when applying for a green card. Gather updated country condition reports, evidence that the persecution you fear still exists, and documentation of why you cannot safely return to your home country. Sixth, avoid any immigration violations, no matter how minor. Do not overstay any visa. Do not work without authorization. Do not make misrepresentations to immigration officers. And comply with every requirement of your status. In the current environment, violations that might have been forgiven or overlooked in the past are being used as grounds for denial and deportation. Seventh, consult with a qualified immigration attorney before making any major decisions. Immigration law is complex, and the Trump administration's policy changes have made it even more unpredictable. What worked last year may not work today. An experienced attorney can assess your specific situation, identify potential problems, and develop a strategy to maximize your chances of success. Eighth, Stay informed about ongoing policy changes. The Trump administration is issuing new directives and guidance regularly. What I have described today may be supplemented or modified in the coming weeks and months. Subscribe to US Visa Info to receive updates as they happen. Follow official sources like USCIS, the State Department, and reputable immigration law organizations. Ninth, be patient and persistent. Processing times are longer, denials are more common, and the system is more hostile to immigrants than it has been in decades. Many cases that should be approved are being denied, requiring appeals or motions to reopen. Do not give up if you receive a denial. Consult an attorney about your options for challenging the decision. 10th, take care of your mental health and well-being. The stress of navigating this immigration system is enormous. Reach out to community organizations, support groups, and mental health professionals if you are struggling. You are not alone, and there are resources available to help you through this difficult time. The Trump green card rule changes represent a fundamental shift in how the United States treats immigrants seeking permanent residence. The system has become more restrictive, more unpredictable, and more punitive. Cases that would have been routine approvals are now being denied. People who followed all the rules are being punished for minor technicalities or past circumstances beyond their control. Families are being separated, careers are being destroyed, and lives are being upended. These changes affect millions of people, current green card holders living in fear of losing their status, applicants who have invested years and thousands of dollars into the process only to face denial, U.S. citizens unable to bring their family members to join them, employers unable to retain valuable employees. The ripple effects extend throughout the economy and society. Here at US Visa Info, we are committed to helping you navigate this challenging environment. We will continue to monitor every policy change, analyze its implications, and provide you with the information and guidance you need. Immigration is not just a legal or political issue. It is about human lives, families, dreams, and the fundamental question of who gets to call America home. If this video helped you understand the Trump green card rule changes and what you need to do to protect yourself, please give it a thumbs up and share it with anyone who needs this information. Subscribe to US Visa Info if you have not already, and turn on notifications so you receive immediate alerts when new policies are announced. Leave a comment below, sharing your experience or asking questions. Are you affected by these changes? Have you faced denial or additional scrutiny? What concerns do you have? Your stories and questions help build a community of people supporting each other through this difficult time. Your dreams matter. Your family matters. Your future in America matters. Stay informed, stay strong, and do not give up. This is US Visa Info, and I will continue to bring you the information you need to fight for your place in this country. Take care and stay hopeful.